are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is Ferguson versus State of Florida. You may proceed.
Thank you, Your Honor, and may it please the Court. My name is Christopher Handman. I represent Mr. Ferguson. I'd like to focus this morning principally on two related claims: the Circuit Court's denial of the clemency claim and its related determination regarding the motion for determination of competency. Now,
on the clemency claim, could you start off by explaining when Mr. Ferguson would have first become eligible to be considered for clemency?
The first time he would have been eligible was in 1986, which is when the governor first initiated that proceeding. Well,
okay, 1986. So he's been eligible to be considered for clemency since 1986.
That's correct.
Well, isn't it a little late in the day to be bringing up a clemency issue here all these years later, only when a warrant is signed? Why are you not time barred?
We're not time barred for the same reason that this court has never applied a time bar in Gore, in Bundy, in Johnston, in Merrick. All of those claims, as the state is fond of reminding this court, rejected types of clemency claims. Not one of those situations, not one case, did this court suggest there was a time bar problem. And all of them, like Gore, Merrick, and Johnston, date back to an initial clemency hearing in 1987.
But we certainly didn't hold expressly that there was not a time bar.
You didn't.
And if you read our case law, you will know that we will go off in different directions depending on what seems to be the most expeditious way to deal with a particular claim.
But I would suggest that there was something more to it than simply looking for an alternative holding. The reason why it makes sense not to apply a time bar to this situation, and the reason why the triggering mechanism is the signing of a death warrant, is because the petitioner has no obligation to go out and seek that clemency petition. The only reason...
I don't... What do you mean, an obligation? If he wants clemency, why wouldn't he seek it?
Because the way the law is structured, Your Honor, is that clemency must precede. Some clemency hearing must precede the carrying out of the death sentence. That's what the Harbison case stands for. That's what the Supreme Court's decision in Woodard stands for. So an inmate
you're saying every defendant is entitled to a clemency hearing?
Sure. And I don't think there's anything particularly radical about that proposition. That's the fail-safe mechanism that the Supreme Court recognized in Harbison.
But my question really is the defendant entitled to be present at the clemency hearing?
Yes, absolutely. And I think that that's a key component to the minimum level of due process that the Supreme Court recognized in Woodard, and that this court in Merrick confirmed there were 5 votes in the Woodard case to mandate some minimum level of due process. And
what is a defendant going to present at the clemency?
There are any number of situations that the defendant can present. One, his personal background. In Mr. Ferguson's case in particular, as we've demonstrated, this is someone who's had a torturous mental health history for over 40 years. He can be able to discuss that. He can talk about the family situations. And that was particularly important here because although courts have rejected ineffective assistance of counsel claims, his initial counsel at both of his trials failed to present any mitigating evidence relating.
So Mr. Ferguson is going to present this information himself?
Oh, of course not.
Or will his attorney do it?
His attorney is going to do what attorneys
If
often...
Mr. Ferguson has had this so-called mental history of not being able to speak, how can he all of a sudden be able to function at a clemency hearing?
Well, that's exactly the point.
Isn't this like a catch-22? Didn't he have a clemency hearing when was scheduled for him and he couldn't appear?
Exactly.
Because of what?
Because he was incompetent.
Okay.
And that's exactly the point, though. If you recognize that competency is required to have a meaningful, sufficiently minimal level of due process type of hearing, then of course you do what the parole commission did. If you look at Exhibit A...
But the reality is the minimal level of due process has not really been defined by the U.S. Supreme Court. Justice O'Connor suggested if clemency was decided by flipping a coin, that would raise due process concerns. Or if a defendant was precluded from submitting any sort of information. I think that's the other thing that she specifically mentioned. But we don't have anything like that here. There's nothing that shows that to the extent that Mr. Ferguson and his counsel wanted to submit information to the governor and the cabinet that would bear on a request for clemency and consideration of clemency, that was in any way precluded for all these years since 1986.
Okay, Your Honor, I think that question raises 2 questions, a time bar issue and a merits question, getting back to Justice Perry's question. On the merits question, the whole reason why the Parole Commission in the first place had a competency hearing and why it said at page 5 of the transcript and page 8 of the transcript that it was postponing was because he was incompetent and because his lawyer was powerless to present any information because he couldn't even converse with his client. There is testimony from...
But don't we know from things that have happened in federal court that there were judicial determinations that he was not incompetent?
There were determinations in the federal habeas that he was competent at that point to proceed with his representation. Now, that doesn't, however, this gets back to the time bar question. The question is, what's the nature of the right? The nature of the right here, and we think this is based on Harbison as a fail-safe, is that a defendant is entitled to clemency hearing before the execution is carried out, before the sentence is carried out. Now, if I'm entitled to some type of process, I don't have to speak up. If, for example, in a foreclosure situation, if you can't foreclose until you've received a certain notice, even if you know you've been defaulting for months and months and months, you can wait until you get that notice. The same thing is true here. An inmate doesn't have to speak up and say, give me my clemency hearing, until it's proven that there's been a violation. The violation occurs when the governor attempts to carry out an execution without going through that very minimal process. That's why this court, I would submit, has never until now suggested that there is a time bar type of question here.
Clemency is a matter of, how is it stated? Executive grace?
Well, that's, I think, an important contention, because this court's previous cases in Askew dating back to the 70s did formulate it in terms of grace. But I don't think that formulation can be harmonized.
Is there total discretion once the governor and the board hears everything that is presented on, in this case, your client, Mr. Ferguson's behalf, and they deny clemency? What is the review from the denial of clemency?
Zero.
Zero.
Exactly.
It's completely there. I understand when you're down to the wire, you've got to come up with whatever you're going to come up with. But what I don't understand here is that it's clemency from that he's going to leave death row, so he wouldn't have to be on death row. In other words, if in 1986 they had granted clemency, what would have happened?
Yes, that they would have reduced the sentence to life imprisonment.
So we have, on one hand, a claim that this man has been on death row for how many years?
34.
And yet, from 1986 until 2012, he doesn't raise the claim that he'd like to be off death row through clemency. See, that's why, to me, I appreciate that you're raising it, but it seems to me that it's virtually a meaningless right for a defendant who is trying to ask for clemency at the moment the governor has determined he's ready to be executed. The governor's made that determination that he shouldn't get clemency.
Well, but that gets to the very question of what's the right of the clemency in the first place, and what are the minimum due process standards? If the governor simply flips the coin to determine that question, we know from Justice O'Connor's opinion in Woodard that that's insufficient. We don't know what process, if any, the governor used here. That's one of the key problems. And the circuit court
would we ever know what process the governor uses to determine if he's going to call a clemency hearing or not? I mean, the whole notion that this defendant, after all this time, is now, please take me off death row. It just is troubling.
Well, we don't know, of course. The governor can make, in his discretion, whatever determination he's going to make. But what we do know is that defendants are entitled to go before a parole commission. There is a process that Florida has enshrined, and we know that the federal Constitution—
At the time when there was a scheduled clemency hearing, what, if anything, did the defense attorneys do other than say he's incompetent to appear? Did they present any kind of information to the clemency board?
No. And if you look at Exhibit A to our motion below, you will see that this wasn't a failure of counsel. This was the commission itself recognized, and I think this is important, based on the state's own psychiatrist saying this man is incompetent. He doesn't even know who a judge is. He doesn't understand what the nature of this proceeding is. He doesn't understand how important this is. The commission itself said, we can't go forward. We have to continue this. His lawyer wasn't entitled to submit anything, and in large part because his lawyer had simply recently been retained to represent him for that, had not been able to communicate with him, had not been able to present anything independently to the court.
Well, here is the second related issue, which is that you say that the circuit court improperly denied Ferguson's motion for the determination of competency. Competency to proceed in post-conviction, competency to proceed in the clemency proceeding, competency to do what?
Competency to proceed in this 3851 proceeding.
So your argument really would be, if we said that he's entitled tomorrow to a clemency determination, isn't your argument that he's not competent to proceed in the clemency proceeding?
Well, I do think that there's definitely that sort of problem. I don't think that's actually...
Well, that's not sort of a problem. Isn't that the actual problem? If he is incompetent at the present time, is competency to be executed the same as competency to be present and participate in a clemency proceeding?
No, I think that those are slightly different standards.
Which one? The lowest is competency to be executed?
I think that the Ford standard for competency to be executed is the lower standard to meet here. But I think that...
So you're really saying you want a clemency proceeding, but on the other hand, he's not competent to proceed in the clemency proceeding.
Sure, but there's nothing...
So that's the first... You would argue that what we should first do is remand this for a determination as to whether he's competent to proceed.
Yes.
And what did you put on... I mean, what did you put on to make a prima facie case that should be something that is adjudicated by the trial court?
We submitted a motion signed by one of the attorneys, Ms. Brannon, who has met with him on several occasions, testifying to his diminished mental capacity.
What is actually the situation? I mean, because there is a lot in the record about him being a malingerer. What is and how long have you represented?
Our firm has represented him since 1987.
Well, and I assume your firm does this pro bono, so please understand that these questions are questions. We appreciate your advocacy. But, so he has been incompetent according to observations of your firm since 1986 to the present?
Yes.
But yet the federal courts have disagreed. Is that correct?
Well, the federal courts have disagreed at times. I mean, it's important to recognize competency is not a static inquiry. Just because someone may be found competent in 2004 doesn't suggest that they are incompetent down the road, just as, for example, the state of Florida had consistently found him incompetent from 1975 until 1978. 7 different state-appointed psychiatrists consistently said this man is certifiably incompetent and should not be let out of psychiatric institutions.
And in there evidence that shows that he bragged about how he was able to fool them?
Your Honor,
at some point?
No, Your Honor. The evidence of malingering was, first of all,
there's no evidence of that?
No, I said the evidence of malingering before the federal court, I understand, was contested. But the idea that this man was malingering and was someone of borderline mental intelligence.
Well, my question to you, was there evidence that he at some point bragged about being able to fool the authorities?
That's what the state's evidence.
I understand.
Yes.
Yeah, there was evidence of that. It was contested, but
yes,
there is evidence of it,
sure,
which has been accepted by apparently at some line, or evidence similar to that has been accepted by the federal courts.
It has, but again, the important point is that was in 2004. It doesn't indicate that he was faking and that there was some grand conspiracy of his part back in the 70s, knowing that he was going to be on death row in 78, that he malingered and feigned all of his symptoms that persuaded 7 different state-appointed psychiatrists throughout those 70s to say this man is seriously chronically ill. He should not be let out of mental health institutions, and yet the state did let him out eventually. It doesn't reflect the fact that we are now 8 years removed, and Mr. Ferguson's now 64 years old.
What additional facts were alleged in the trial court, other than a lawyer saying I haven't been able to talk to him coherently? Were there additional facts that you allege that would demonstrate that this man is incompetent to proceed?
So there were no other facts other than what we were able to put together, plus, and I don't think this can be discounted, we submitted the mental health supplement, which contains over 200 pages of consistent diagnosis over 40 years showing that this man is incompetent. Keep in mind, Your Honor, that the warrant was signed on September 5th, and we put this motion together and filed on September 11th. So, and I will say, I know this is not this case right now, but there may be another case soon. We have filed under 922-07 a motion about his competency to be executed. There are expert reports that have been compiled about that.
I want to ask about that. It strikes me, although this is what the statute requires, is that competency to be executed will take place in Bradford County, in the 8th Circuit.
Correct.
This case is in Miami-Dade in the 11th Circuit. So we're going to have, if we were to follow your point or agree with you that he needs a competency evaluation to proceed, it seems that there is something inherently inefficient and difficult that we're going to have a judge in Miami-Dade looking at one set of information and a judge in Bradford who has no familiarity with the case looking at another. So he could be and I'm going to ask that to the state. It just seems that there's a difficulty in that we'll have different experts certainly one has already happened. Is there any precedent for those two being consolidated?
Your Honor, I think there is, and the state will correct me if I'm wrong about this, but I believe the last time a 92207 competency to be executed claim was raised was in the Provenzano case.
I remember. That's what I thought it was.
And I think in that case, and again, I invite the state to correct me if I'm wrong about that, that precisely for the reasons Your Honor identified, that matter was transferred from the Eighth Circuit back down to the original 3851 court. And I think that procedure would make sense here, not only because of judicial economy, but also because the circuit court on which we are here on appeal has already recognized that there is, as a finding of fact, that if time bar doesn't apply, that the defense would likely be entitled to an evidentiary hearing on clemency. That is an important finding. We don't come to this court without
What would the
findings.
evidentiary hearing consist of? In other words, we know he had a hearing, but he was incompetent at that time. So what would be offered at an evidentiary hearing?
Well, I think it's largely to deal with the state's points, which is they've suggested that he did in fact have a hearing, that all of the minimal processes that are due were performed. To the extent that that is a question of fact about what actually occurred, and there is a spotty record, as Your Honors may have seen, that would be important to play out, to see what were his recollections, what might he be able to provide to determine whether, in fact, that clemency proceeding did meet and comport with those standards. But the important point that I want to emphasize, I know in my remaining time, is that Mr. Ferguson didn't have that minimal process. And that distinguishes this case from all of the other situations that this court has confronted clemency in Gore and Merrick and Johnston.
What about Valle?
Same thing, because in all of those cases, the key point that this court emphasized with that was that the defendant at one point at least had a, quote, full competency hearing, end quote. Our submission, and the circuit court, I think, understood it, was that he never, in fact, had that. He didn't have the full competency hearing because he was never competent to be there in the first place. And I think it would be an empty right, as the state suggests, that just because he had a lawyer at his side, that somehow fulfills the competency and requirements there.
You only have about a minute for rebuttal.
And then in that case, Your Honor, I will reserve my time. Thank you.
Good morning. Scott Brown on behalf of the state of Florida.
Could you just address this last issue about that there's now going to be a proceeding in Bradford on after the governor had followed the statutory procedure on competency to be executed, that it's filed in Bradford, but yet if we determine it wasn't time barred, that there's actually had a clemency hearing or whether he's competent for those purposes, shouldn't the same judge make that determination?
Well, no, Your Honor. I think by rule there's a reason an Eighth Circuit judge would handle it, because most of the witnesses will be in North Florida. There are security concerns with the inmate. And, again, 2 of the doctors are in North Florida. And there are facilities actually in... So
should the 11th Circuit case be up there? I mean, if I'm a judge wanting to try to figure out whether this guy is a malingerer or if he's certifiably mentally ill and not able to communicate or meets the minimum standard, don't I want as much information as possible about his mental status at the present time?
Well, Your Honor, I would submit that the only mental status at issue now would be the 3811, because
the one to be executed.
The Judge Safi appropriately denied his motion to determine competency to proceed because, quite frankly, these allegations are without merit as a matter of established law. There was absolutely no issue that required factual determination in the court. And again, that's the preliminary question.
Let me ask you, in 1986, is it a fact that at the time that he had a clemency hearing that he was incompetent to proceed, or is that contested?
No, Your Honor. In fact, I do contest that. There were two doctors.
Isn't that something that needs to be examined at the 11th Circuit to know what happened?
No, Your Honor, and here's why. First of all, you don't have a right, assuming for a moment that those doctors who admitted in their own transcript, we just saw him 2 minutes before he came in here, he appears incoherent. So I don't consider that a full-blown competency determination. You know, Mr. Ferguson has a long history of feigning mental illness. But you've got to find an underlying right here to judicial inquiry into the clemency process. And Mr. Ferguson wholly has failed to do that. We know for a fact that clemency is a matter of executive grace. It lies with the governor. And even if you follow Justice O'Connor's concurring opinion in Woodard, the only limitation on the clemency process, and again, clemency is not required by the Constitution, but if you provide it, it can't be simply flipping a coin. There's no evidence that the governor or members of the commission flipped a coin in this case. They sought out Mr. Ferguson. They attempted to interview him twice. He was represented by counsel. Now, there
was never any determination made by that commission as to whether or not he was going to get clemency or not, or was there?
I disagree, Your Honor. I believe they have speculated, like in Valle, that there was no determination. That's not been proven. They didn't call the attorney or the prosecutor.
Well, what do they normally do? In a normal situation where there is, in fact, a clemency hearing, does the board then issue some kind of statement or order denying clemency?
It's my understanding that it's either an oral or a written order, either or, but they deny it. So he has a clemency submission. But again, what we do in this case is what warrants a judicial intrusion into this process.
Well, let me ask just a fundamental question, is that recognizing that it may not be required, but if it is available, that it must meet certain standards, agree with that?
Minimal standards that have not been met.
Whatever. We can argue about what the standard is, but they're standards. And you seem to be interpreting the flip the coin as that's what's prohibited. But isn't that just a figure of speech? Wasn't that used in the context of that the proceeding must be more than just a game?
Correct, more than a game. And right. What courts have done is, if there's an allegation that clemency was denied for some improper basis, race, religion, if there was bribery involved, courts may look into that. But again, it's exclusively under our Constitution a matter for the governor. It's a matter of executive grace. So the remedy here, and again, this goes back to time bar. All of the underlying facts in this case, Justice Kennedy, all of these facts, all of their submissions, all of their facts in support of their motion were available and known to Mr. Ferguson's counsel in the 80s. Why did they spring it suddenly on the eve of a warrant? Not the eve of the warrant, on the eve of the execution. The answer to that is clearly...
I'm still concerned because you said that the board would either make an oral or written statement of denial of clemency. And so, but in this situation, aren't we just assuming that the board denied clemency since we don't seem to have a written or oral statement to that effect? And are we to assume that by signing the warrant that is a denial of clemency?
Yes, Your Honor. In fact, you've said as much in Valle and Merrick that when the governor states in his warrant that I have determined that executive clemency is not appropriate, that is a clemency update, that is the clemency review to which he is entitled before a death warrant is signed. And again, in Valle, you did put the burden on the state to show it occurred, because most of these records, we don't want judicial intrusion into the clemency process. That would be bad precedent. So you put the burden on Mr. Valle and said his claims were speculative, that he never received one. I submit that the claims here are just as speculative, because we know that Mr. Ferguson was represented at all times by Robert Martin, a clemency counsel, to argue his case. He sought a postponement for 6 to 7 days. There's nothing in the record after that suggests that Mr. Martin did not fulfill his duty to Mr. Ferguson and that clemency, a full clemency determination, was not provided to Mr. Ferguson. And again, this type of judicial inquiry, especially on the eve of a warrant, when Mr. Ferguson has litigated his case over the past 30 years, is particularly unwarranted.
But
again,
you say that, because this has come up again, it came up in VIA, I know it's come up, that there is really a presumption when the governor signs the warrant and says what the governor says in there. Clemency has been considered and it was rejected.
Exactly, Your Honor.
Because otherwise, I mean, we get into this, and the only other thing I would be helpful is if there actually was, once clemency was considered and there was some kind of order that was sent out and filed, so the court wouldn't be in this position to say, clemency hearing was held on such and such a date, it was considered and denied. That way we wouldn't be in what we have with VIA to wonder, was one held or not? And it's just something for the future, perhaps, because it seems like this is sort of the last-ditch claim that someone can make at this point. I don't want to, again, I don't want to minimize it, but it strikes me that when the governor has made a decision to sign the death warrant and execute a person, they made the decision that clemency,
it's inappropriate.
had already been considered and it was denied.
Exactly, Your Honor. And again, these are dilatory tactics in this case, because he could have raised this claim. Judge Safey said certainly after 2010 when cert was denied for the denial of his habeas claim.
If a defendant, let me ask you that, if a defendant actually wants to have a clemency proceeding, what obligation is there on the part of the governor and the clemency board to actually have one?
Well, he can seek one at any time, and it's a matter of executive discretion. Once you have the initial clemency by Governor Martinez in this case, nothing prevented Mr. Ferguson from seeking an update or additional clemency.
Well,
the fact that he hasn't done so.
I mean, he's actually saying, and this is where it's that he's been incompetent, and he's still incompetent. So if we were to if the governor was to say today, I'll give you one, say, no, I'm not competent to proceed with it. So they're really kind of going around.
It's
I mean, that's
clearly
what I'm
an
hearing.
attempt to delay his execution, Your Honor. And again, on the issue of incompetence, we had a week-long federal evidentiary hearing in 2004 in front of Judge Daniel Hurley. All of Mr. Ferguson's mental health history dating back to the 70s was at issue. Evidence was introduced and discussed. The state presented its experts and he presented his. It was abundantly clear that Mr. Ferguson, once again, feigns mental illness. He malingers. He leads an absolutely normal life on death row. He writes letters. He meets his needs. The psychological testing left no doubt, even by Dr. Richard Filson, who was retained by Ferguson, that he's exaggerating. His own expert administered the MFAS, which is a well-recognized test, and it shows that he's malingering. So all of these tests, including the MMPI, come back, he's malingering. The guards don't notice bizarre, unusual behavior. According to Mr. Ferguson, he's constantly psychotic, but no one notices. Now, Mr. Ferguson feigned mental illness back at his trial. He feigned it again in post-conviction in the 80s, and we have another finding by a state court judge saying he feigns, he exaggerates, he malingers.
Let me make sure in this case that no judge has found him to be incompetent to proceed at any time.
Not under these capital cases. That is correct. None.
What does that mean?
From the Carroll City or Hialeah trials. There was an earlier not guilty by reason of insanity, and I believe there was some delay.
What year was that?
75. And
all right,
again,
so a jury made a determination?
On one of his cases, that is correct, in the 70s.
It's not exactly like there's no mental illness, or is there?
No, I don't believe there is.
So we think the jury, he just put one over.
He did put one over. Now, Mr. Ferguson claims that he's borderline retarded and could possibly fake mental illness. That's not true. Dr. Richard Filson administered the latest Wechsler intelligence test to him and found that he's of average intelligence.
What is his intelligence?
He was 94 and
not close to borderline.
Not even borderline. He's of average and is actually above average in the verbal range. So he's pretty smart.
In the capital case, then, this capital case, he has never been found incompetent to proceed by a judge.
No, to the contrary. He's been found not only competent, but more than that he malingers, he exaggerates.
And therefore, the issue of whether he of competency at the time of the clemency proceeding was something his lawyers just presented. There wasn't a finding even at that time that he was incompetent at the time.
No, what they did was Robert Martin said that I talked to him this morning, he was fine, and then when I went over for the clemency interview, he decompensated and became crazy. Well, he's a good actor. And we know that about Mr. Ferguson. But there wasn't no judicial determination at that time, and none is required. There's no case law, even assuming for a moment that Mr. Ferguson is truly mentally ill, and I think the evidence now is very clear that he may be a psychopath, and I believe he is, but he's not a paranoid schizophrenic as he claims to be. And again, if you go through all the testing, all of his history, going back to the early days, they blame the state for releasing Mr. Ferguson in 1976. But we released him because he wasn't mentally ill. The releasing doctor said he's not mentally ill. That's it. He's a psychopath.
After his not guilty by reason of insanity.
Yes, Your Honor.
So he was being treated
at the state
that
hospital.
Point, and then the doctor said he is not mentally ill and he should be released.
Well, they did say that he's a psychopath, and we know that. And there's only one clean MMPI. And what I mean by it's not invalid by over-responding. And the clinical scales are normal except for 4, which is the psychopathic deviant scale, and 9, which is hypomania. So he is an energized antisocial. That is what I believe his genuine mental illness is. But it certainly doesn't render one incompetent. It makes them dangerous. And again, there was the most extensive hearing in 2004, and it was 5 days on nothing but Mr. Ferguson's mental health. And the results, according to Judge Hurley, were very clear. He malingers, he's feigning mental illness. And again, the mental health submission below ended in 2004. So what Mr. Ferguson presented to Judge Safey was misleading. And the last things that he attached were 2 doctor reports, Dr. Marikengis and Dr. Filson. He neglected to mention that those 2 doctors were found not credible by Judge Hurley after testifying in court.
Is that in a written order?
Yes, Your Honor. And I've provided that to the court, and the court below took judicial notice of the federal competency hearing. Again, and I think what Mr. Ferguson is doing, understandably perhaps, but he's trying to conflate again, a competency claim that has been repeatedly rejected, and now he's adding in a clemency claim, the facts of which were known to him and his present attorneys back in the 80s. Why are they raising it now? It's simply an attempt to delay his execution.
So have we ever held, because that it's time barred if you've had anything that's called clemency and you don't raise it as it was not meaning, well, again, I guess that's the question. He's saying he didn't really have one. So if he didn't have one, then when does the time start to run for raising that you didn't have one?
Well, I think Judge Safey thought it ran from the time certiorari was denied on the denial of habeas. The state submits it's under Rule 3851 when the facts were known or could have been known by due diligence. And he clearly, there's a letter from Mr. Prettyman of Hogan and Levels, Hogan and Hartson at that time, noting the clemency process and complaining about it. So why are we now here? I mean, clearly it's time barred. And again, Your Honor, I agree with Mr. Ferguson's counsel that this court has not recently found any of the clemency claims time barred. But I think it really should, because what we're seeing here in every capital case now is, clemency, we're not sure what it means, but we'll throw it out there and maybe we can delay our execution. It's not a legitimate claim. It's a matter of executive grace. The governor made that determination that clemency is not appropriate in
All
this
I'm
case.
saying on that, because whatever we decide when I know when the warrant is signed and there's a whole series of the proceedings that are presented, it would really help this court, at least this person here, if the statement was made, clemency hearing was held on this date, just so that we have it. It's in maybe is it in there? But it would, just for the future.
And I appreciate that, Your Honor. And again,
counsel, isn't it the fact that in the warrant there's an express statement that the governor has determined that clemencies will be denied?
Exactly, Your Honor.
Now, is there any law that establishes that there is a right to a hearing that cannot be waived, or any right to a hearing as opposed to consideration of clemency.
No, Your Honor, absolutely not. And he got consideration of clemency, and the state rejects any notion that his submissions show that he did not get such a hearing.
But you're saying there's two different things, and one is, can the governor just make that determination? But I thought what we were talking about is something that happened in 1986.
Well, the underlying facts were clear to Mr. Ferguson and his counsel. Yes, there's an initial clemency, and then there's the clemency update. So what is Ferguson really asking this court to do? Send it back to the governor for another determination where he's already determined that clemency is not appropriate?
Well, that's why I'm at. So isn't there a presumption then, at the time that the governor signs the warrant, just what Justice Kennedy says, that clemency has been considered and been denied?
Exactly, Your Honor. That's true. But again, and I wish this court, again, we see these kinds of claims on every death warrant now. I think it's important to start enforcing Rule 3851, which requires diligence in bringing claims. And again, if he thought his clemency process was unsound or infirm in the 1980s and his counsel knew about it, he should be time barred. And we ask that this court deny or affirm, the denial of post-conviction relief in this case. Thank you.
To clarify the nature of this right, it is the governor clearly has the ability to deny clemency, but he can't do that unless, as we know from Woodard, minimum levels of due process are followed.
But we don't know from Woodard or from any other case that the governor is required to hold a hearing on that.
What we do know is that there have to be minimum levels of due process, and what is the very minimum here, in at least the way Florida has enshrined the clemency process, is a hearing. That's why there are regulations, in fact, laying that out. That's why at this time, when Mr. Ferguson was going through it, you had to expressly sign a waiver if you didn't want to be interviewed. That's recognized by the state. This is not simply the council inventing this right. And if that's true, it's not enough for the governor to conclusively assert. And by the same token, we are not Valle. We are not, as in Valle, simply speculating whether there may or may not have been a hearing. We are pointing specifically to the hearing, and we're saying that's not enough. This is not enough. When you put someone through, and the state's own psychiatrists, two of them, by the way, Dr. Infante and Dr. Parado, both of the DOC, say this man's incompetent. And it's not a gauzy, we think he might have some problems. If you read the transcript, this is Exhibit A to our 3851 motion, pages 5, page 8, that testimony couldn't be clearer. This guy doesn't know what the importance of today was. He doesn't understand what a lawyer is. He doesn't understand these proceedings. That's the essence of our claim, and we would respectfully request that this court reverse, stay the execution, and remand, as the circuit court said, and at findings 3 and 4, that there has been no adequate hearing. It requires one once you determine there's been no time bar. Thank you, Your Honor.
Thank you for your arguments. The next case today is Governor Graham versus Senator HARIDOPOLOS. Counsel ready to proceed?
May it please the court. My name's Robin Gibson. I'm a lawyer from Lake Wales. I represent the individual petitioners in this matter. And I received my instructions from the clerk. And the clerk says that I am to give a short, that's underlined, concise statement of the points relied on for reversal. So, to assure brevity, I have written it out, and it takes 1 minute and 32 seconds. The issue, how much authority was transferred by the amendment to the Board of Governors, and did it include the authority to set tuition and fees for state universities? How much was transferred to the Board of Governors? All legislative Article 3 power over universities. The plain language of the amendment, : the power to operate, regulate, control, and be fully responsible for the management of the whole university system. How much was retained by the legislature? The authority to appropriate for the expenditure of funds, confirm appointments to the board, and set members' staggered terms. The setting of tuition and fees is not an exception to the transfer. Where the First District erred, by enabling the legislature to set and appropriate tuition and fees based on its Article 7 authority to levy taxes. The requested remedy. Statutes still purporting to exercise control over universities, including fee setting, have been repealed by the terms of the amendment, should be declared unconstitutional, and removed from the books.
Well, you've succeeded in having 1 minute and 30 seconds where no one interrupted you with that. That was very good.
Probably a record for this.
That is a record.
That's unprecedented, actually.
I think that's going to be the last 1 minute and 32 seconds where that occurs.
Power to set fees and tuition. That's really what the case is about, correct?
I think the case is first about what is the scope of authority that's transferred, and then is fees included in that?
But that's the argument. It's not about the management of the university at this point. It's about the power to set fees and tuition. Now, is that a executive branch function or is it a legislative branch function?
Legislative.
Yeah, because I was wondering, because I know this branch would love to keep its fees that we generate for ourselves, but it's the legislature that gets to decide how it's spent and how we're funded. What my concern is, and I think it's there's a lot of different ways to get there, and I know you were counsel at the time of the oral argument when you represented that what this was about transferring the executive functions, not legislative. And we all know that the ability to set fees and tuition would be a revenue raising, which is a legislative function. So what is, and the other part, so we have that, which is that that's legislative, not executive. The other, and that there might have been a single subject concern if it also subsumed legislative or included legislative, is the language of the amendment itself that, unlike some of the other states, does not have mention, which would seem to be so easy to put in, that includes not only the management of the university system, but the ability and power to set fees and tuition. So I know that's probably three, but that's my concern. And it may have been the intent to do it, but I don't see how it could have been done without violating the single subject mandate of Citizens Initiative, number one, and number two, how the actual amendment clearly encompasses the power to set fees and tuition.
All right. I think there are at least two questions embedded in that. First has to do with the executive part of it. And at the time, the executive, the function of administering universities was in the executive article of the Constitution. And although it was legislative, the legislature appointed the Board of Regents, and they were to do it. So it's found in the executive article.
And we're
after the transfer,
no one's contesting that power was completely transferred. So the legislature could not continue to sort of jerk around what the Board of Regents and all the other governing bodies. No question.
After the transfer, it's moved to Article 9. It's in the education article. So it's out of the executive article. I think the second part of your question had to do with the amount that was transferred. And in this particular case, and this court most recently in the Caribbean case, there's a method of analysis as to how you go about determining what was transferred and whether the particular question is involved in that what was transferred. And there's even a test for whether some or all of the authority was transferred. That's all in the Caribbean case. Now, the language of the amendment is what controls, and this language says that the authority transferred is to govern, operate, manage, control, regulate, and do it in a corporate form. And it further says that the full responsibility for the whole university system is transferred. Full meaning all of it. For the whole university system is the entire university system. I've included 27 provisions that in the state constitutions that across the country that have something to say about universities in the Constitution. And you can lay them side by side with this amendment, and you find that this amendment is the most all-inclusive, total, complete transfer of authority. So all the authority that the legislature had was transferred.
But it can't. You see, the problem is, though, that you can transfer executive functions, but you can't at the same time transfer in one amendment executive and legislative functions. And that was what was represented to this court when the court upheld it as not violating the single subject provisions of the Constitution. And that's my, I don't, and we're not going to go, we have all the other states, so we know if there are differences or similarities. I don't still see that I understand how in management of the university system that necessarily, undeniably, unambiguously includes the power to set tuition and fees in that particular phrase, management. How does that, I'm missing something on that.
Well, I don't know why it was located in the executive branch, but it was in the executive branch. We had nothing to do with locating it there after the legislature, who had full control. The legislature created, operated, and terminated the university system, so it was all legislative. But one thing's for sure, after the advisory opinion, this court set it straight as to what the situation was. And in that advisory opinion, it said that what would happen, the power would move to an independent constitutional entity. This became the third of those kind that we have. And that at the time, the legislature was responsible for the operation, regulation, control, and full responsibility for the management of the university system. If the amendment were passed, that would become the Board of Governors' responsibility. And all you have to do is look in the statutes to see what passed. And in the statutes, 1009.24, there is the setting of tuition. And somebody says, well, you should have said that the tuition would pass. Well, think of the 1,000 things that the governing board for universities do. Should we have said that we set presidential salaries?
Hold it a second. I mean, really. And again, it's not that I don't probably share some of the frustrations as a citizen as to whatever is happening in this university system. I'm looking to say the power to set tuition and fees and collect those and then decide how they're expended. Again, the judicial branch, which is a co-equal branch of government, has no control over the appropriations. That is legislative. It's found in a separate article that wasn't referenced in the ballot summary or before this court. So I don't think it's the issue that they had to set forth every small little thing, but the power to set tuition and fees and then appropriate that money from tuition and fees seems like not a little small detail.
No. And now we're on the question of appropriations. The power of appropriations did not pass to the Board of Governors. The power of appropriations remains with the legislature. And as a matter of fact,
let me ask you about appropriation.
Yes, ma'am.
First of all, when fees are collected from the students at these state universities, where does the money go?
The money is collected by universities and stays with universities.
And it stays with the university, nothing goes to general revenue?
That's correct.
And what about the fees? Is that the same as the
fees
tuition?
are the same thing.
So the legislature what the legislature appropriates are additional monies to all of the state universities in addition to the tuition and fees that are collected?
Okay, we're talking about two different things. One is the collection of fees and the other is appropriation. Let me go at them one at a time. All right, first, the collection of fees. There's a distinction between a tax and a user fee. And what we're talking about now is fees. A tax is something that is mandatory. It goes into the general revenue. It can be used for any purpose.
But we're talking about fees such as when the students want health care or some
I'm
of
drawing
those
a
things.
distinction. Here we go. A user fee is a non-compulsory payment from the beneficiary of the service. It is spent to defray the cost of the entity's service, and it's paid by virtue of a voluntary contract. This court has drawn that distinction in the case that was included in supplemental authority by the legislature, the state versus the city of Port Orange. And in that case, after drawing that distinction between user fees and the taxes that goes into general revenue, it says that the Board of Governors, it says that the proprietary right of the governing body to assess the fee. Now, what that means is the people who have the responsibility for operating the enterprise also have the responsibility for setting the price for the service that is rendered by that enterprise.
Does the record show how much of the funding for the state university system actually comes from appropriations from the legislature as opposed to the fees and tuition?
Yes, sir. What we've done, this was filed in 2007, and what we have done is use the figures for 2007, and we've used the Appropriation Act for 2007, and in 2007...
Well, just give me a percentage. I'm interested in kind of getting a ballpark idea about how much of it actually comes from the legislature.
Well, for the University of Florida, it was the general revenue was $392,000, and for fees it was $183,000. So the percentage can be calculated.
I'm not following those numbers.
It couldn't be thousands.
I'm sorry, it's million.
Well,
when it gets to millions.
How much from the football team?
Yeah.
So it sounds like a third of how a university operates actually comes from the tuition and fees?
That was in 2007. I fully suspect that it's more now.
I'm sorry, I thought you said the tuition gets collected.
Right.
Are you saying that the way it works is it goes into the University of Florida's bank account and then they get to just decide where that tuition is going to go? I thought it went into
the way
a
that
trust
it works,
fund by the legislature.
You can take a look at 21532, which lays this out.
Where does tuition go? Are you saying that the university's been spending tuition without legislative oversight?
Here's the way it works before the amendment.
Now,
Since the amendment, it's been balled up. But before the amendment, this is the way that it works. First, the universities are funded by general revenue. That
Correct.
supplements what they bring in for operating the entity. What they bring in for operating...
Well, actually, it's kind of the other way around.
It's the other way around.
What they bring in supplements the general revenue, if I understood the numbers correctly. Isn't that right?
I would
the supplement is lesser than the other.
I would put the fees first, and then to meet the expenses, you have to come up with a general revenue. That's what Article 7 says. But at any rate, chicken or egg, you wind up with the total amount for universities. And this is a very important statute which makes the distinction between these funds that you're talking about. The general revenue funds are from taxes. They can be used for anything. They supplement the universities, what the universities bring in. They make state universities. All right. The fees come in. The fees are what the users pay.
The tuition. Let's talk about
tuition.
But I'm asking you, where have they been since the amendment passed? Where have those, when you collect them, like we collect filing fees, we've got to give them to the state.
Right.
Have these fees, the tuition's been collected and kept by the universities?
Let me try. It was neatly done before the amendment. And under 215.32, what happened is they came into the universities. They were to be used only by the universities, and that's why they call them trust funds. So they stayed with the universities.
Trust funds. Okay, so now we're talking about a legislative trust fund.
Yeah.
I mean,
if you go into a state park, you pay an admission fee.
We know what trust funds are, believe me.
Okay.
We know that the legislature can take our trust funds, which they routinely do.
Well, if it's a trust, I don't think they're supposed to, but that's another question. But if you go into a state park and you pay an admission fee, it stays with the state parks. And that's the incentive. You work hard, you earn these fees, you get to spend them. And that's why they are trust funds.
You're in your rebuttal time.
All right, sir. 215.32 makes the distinction between the two. One is Article 7, which is the general revenue, and the other is Article 3, which is the legislative power, and user fees are all set by the legislature, and that's what passed to the Board of Governors.
Is there anything in Article 3 that actually addresses fees and tuition? I didn't find
it. Says that the legislature has the legislative power, and then what that power is, you look at the statutes, that's the way they exercise the power.
You're just relying on Article 3, Section 1?
Yes.
Okay.
And you look at what the legislation is, and that shows you what the power is, and there you find the assessment of fees.
May it please the Court, Daniel Brown, Carlton Fields for respondents.
Can I, because I didn't have a chance to really understand this, give me a real-life example of what has happened since the amendment passed. Are the tuitions and fees from each of the universities being taken away by the legislature to be used for some other purpose? What is... is there one event or has it just been since 2004? This has just been, again, a controversy between the legislature and the governing board, which...
Justice Perry, if I understand your question, the first part of your question was whether or not since the passage of this constitutional amendment, the legislature has taken away tuition and fees from the university and used them for other purposes. The answer to that is, in this record, there's no evidence of that, and I know of none.
Okay.
With respect to what is your question to counsel for the petitioners about what happens to tuition and fees, as we point out in our brief, what happens to tuition and fees is the same today as it always has been. The legislature has created over the years a continuing appropriation statute. There is still one on the books. It's cited in our brief at page 15. And it says, except as otherwise provided in the General Appropriations Act, all monies received by the universities from student fees, and that's tuition and the others, are hereby appropriated for the use of the universities, and they're held in a university account. That does not...
They are free to use that money Or does the legislature tell them how to use those tuitions and fees that are collected?
There's nothing in the acts that are being challenged here today in which the legislature directs the precise usage of the tuition and fees that the universities are allowed to keep. The question before this court and the statutes challenged here have to do with who has the power, number one, to determine what the level of tuition will be. Is that a legislative power or a power granted somehow by Article 7 to the Board of Governors? And number two, once those fees are set and raised, who has the power to appropriate them? Now,
so did they change the fact, or did any of these statutes change the fact fees and tuition go to the university? That has not changed.
No, Your Honor, it has not changed. But bear in mind that it has always been the case that the legislature, through the appropriations process, can decide, if they wish to revoke the continuing appropriation of those tuition fees to allow them to be held outside in the university accounts, and say, put it into the state's general revenue funds, and we'll appropriate it out of that.
Well, in the law schools, deans are always trying to raise money by every which way, and there are generous donations. Those don't fit into any of this, correct? That money just goes straight to the university.
It has nothing to do with donations. It has nothing to do with grants and aid from the federal government. It has to do only with who has the power.
So it's tuition and fees.
Over
not
tuition and student fees.
If they are awarded a grant or a contract, that remains with the university.
Right. If you've got a donation, obviously the donor can control how those funds are used and can put reverter clauses in their gift, that if it isn't used that way, it goes back. The same thing with the federal government because of the supremacy clause. If they want to put conditions in the grants and aids that the state gets for the university system, that's not involved
So
here.
when there was a decision, last year there was something I know the University of Florida was lobbying for before the legislature about there being like super universities that could set higher fees. What was the argument would be that they would be allowed to do that on their own, that University of Florida could make a decision as to how much to raise their tuition without regard to legislative input. Is that correct?
That would be the university's position, yes.
And why is that the power to actually set the amount of the tuition? Why is that a legislative function as opposed to the function that was transferred when this governing system and constitutional entity was set up?
Well, I think there are probably about three answers to that, Your Honor, so let me give them to you in roughly the order in which I think they have the most importance. First of all, that has always been the power of the legislature when this amendment was adopted. That has historically, unquestionably, always been within the legislature's power.
And it was an exercise of a power that was tied to the appropriations power, correct?
That's correct. That's point number one. Point number two, there is nothing in the amendment's terms or its title itself or in its ballot summary which even remotely hints that power would be transferred to the Board of Governors. And number three, where is the affirmative power of the Board of Governors to do such a thing? Now, Mr. Gibson claims it's a proprietary right, and he cites this court's decision in State versus City of Port Orange. The problem they have is this. In City of Port Orange, and in every other case that has decided a user fee question, the courts have uniformly said, as the City of Port Orange says, quote, user fees are charges based upon the proprietary right of the unit of government that's exercising the power. Now, that means property right. The problem is that since at least 1993, and in the current code and statutes of the state, the universities have no proprietary right in the lands and buildings funded heretofore. Section 101.706, subsection 6 says, all title to real property acquired prior to January 7, 2003, and all real property acquired with funds appropriated by the legislature thereafter shall be vested in the Board of Trustees of the Internal Improvement Fund. Neither the Board of Governors nor any university is vested with proprietary right that would allow them to use the user fee analysis to justify their power to set fees.
It seems this comes down to, as Justice Kennedy indicated, if the aspect of regulation and control flows from the power and obligation to appropriate, then the question is this amendment has severed lease management control, and does it carry along with that the right to set the fees and tuition? Isn't that really what we're talking about?
That is what we're talking about.
I mean, that's the essential heart of
this. That's the essential question.
Right.
There is, however, another question, though, and that is, and has been at the center of this case, what is the scope of the legislature's appropriation power? Now,
because we know from the amendment that expressly that the legislature kept that.
Yes.
Because that is expressed, and maybe we'd have a different case if this amendment did not say that, although we get into then questions about the way the amendment was presented to the people, but I'll leave that aside. But the amendment specifically reserves the legislature's appropriations power.
That's correct, Justice Kennedy.
But isn't that a very important fact for your case?
That is critical and essential to this case.
But it's the interpretation of that as to what goes along with that, whether the setting of fees and tuition are part of that process. Because as you discussed before, the other elements that were transferred were inherently part of that, correct?
Not quite, Your Honor, if I might. Let's take for a moment, we don't agree, obviously, for the reasons I'm articulating now and then articulated in our briefs. We don't agree that the Board of Governors ever achieved the right to determine what tuition fee level setting would be in the first place.
Well, I mean, that's a question of interpretation of managed control, et cetera.
Let's assume for just a moment that they did. Okay, let's assume that the power to decide what tuition and fee setting would be transferred. I don't agree with that, but assume it for the sake of argument. That didn't change the appropriations power. Right. As this court has held, in advisory opinion of the governor, cited in our brief involving Governor Kirk, monies raised by a state agency are received from whatever source. Doesn't matter where they come from or who sets them. Must be appropriated by the legislature before they may be expended.
Could you address that? And that's in Article 7, Section 1, the constitutional duty of the legislature to raise and appropriate state funds. The argument is being made that the power to set tuition and fees is actually not derived from Article 7, Section 1, but from Article 3, Section 1. What is the response to that?
My response is that's incorrect as a matter of
is there any case? I mean, I guess is there any case law that actually puts that into the?
There is case law, Your Honor, that says, and from this court, it's cited in our brief, that cituses the power of appropriation in Article 7. Okay, there is no case specifically on point, although Childs versus Children, A, B, C, and D referred to the legislature having the power of the purse, both raise and appropriate monies. Article 7 itself says two intertwined things. One, the legislature shall raise revenues sufficient to defray the expenses of the state. It doesn't say general revenues, it doesn't say taxes, it says revenues. So the legislature is constitutionally given the power to raise revenues to defray the expenses of the state. In the very preceding paragraph, it says no monies from the state treasury may be withdrawn without an appropriation from the legislature. I submit to you that there is no case law out there making that point any clearer, because the Constitution itself is crystal clear about where the power at the state level to raise and appropriate funds lies.
I think there's
Because I thought I heard that we have the pot of money that's tuition and fees. Have the money that is actually appropriated by the legislature. Is that correct?
No, Your Honor. In fact, I think that's incorrect.
Oh, okay.
The legislature appropriates it all. Now, what they have done historically is they have created a continuing appropriation by statute. It says we don't have to deal with it every year in the General Appropriations Act. As long as that statute is on the books, the money that is collected by tuition and fees is hereby appropriated for the use of the universities.
But not in any specific way.
But not in any specific way.
But the monies that actually come from general revenue, I'm using general revenue in the term of it's not tuition and fees. Those monies are actually appropriated for specific categories. Is that correct?
They are appropriated in categories for use, but not down to minute detail level.
It just seems to me that this really is sort of two pots of money here. The legislature just gives general authority to use the tuition and fees, not specific category. Is that correct or not?
At the present time, that's correct, Your Honor.
But I guess, and this is sort of a question I had, I was trying to look for it. Article 9, Section 1A still provides that the legislature has to make adequate provision for the established maintenance and operation of the Florida universities. That was not taken out of the legislature's responsibilities.
No, it was not, Your Honor. As we point out in our brief, maintenance or maintain means provide funding for.
So that it really, if we started to have this as an all-out fight where the legislature said, listen, you take your tuition and fees and you raise them as high as you want to raise them, but we're not giving you any more general revenue, we would really have a crisis in this state, wouldn't we?
Potentially, Your Honor. Frankly, I think the position of the legislature would be under the established precedent from this court. Even if they could raise the fees, they can't spend them at a level not appropriated. And that is perfectly...
I mean, raise the amount, not when you say raise it, they could
set
the level of the tuition.
But could not spend the resulting funds without appropriation from the legislature.
What was the statute last year that I'm thinking was either going to be passed or was passed and vetoed about the super universities? Is that about University of Florida and others?
There was a question as to there was debate as to whether some universities should be allowed to set tuition levels at substantially higher levels than other universities for the purpose of making them.
But that was being sought in the legislature.
That was a discussion in the legislature.
But I mean, if this is correct, they wouldn't have to go to the legislature. They could do that within the power granted in article in the amendment that we're talking about, right?
Well, in that case, Your Honor, in that hypothetical case, I think what would happen is this. A university might try to set its tuition levels where they want to, but when they want to spend that money next year, they're going to have legislative appropriation to do it. And if the legislature says, I don't care how high you set your fees, we think the mix between taxes and what students will pay in tuition is going to be X, and you cannot spend more than X.
I mean, and that's really the problem, is why this seems legislative, because this is not like a little supplement that's being provided by the legislature. And I think it's even though they may be in different pots, they're all going for the same purpose, which is to provide a quality education for the citizens, the students that enter the university system. So that would be tough, right, if it was segmented that way.
It would, Your Honor, and just for clarification's sake, for 2007 figures, the funding for the state university system as a whole, not for each university, but the funding itself, broke down approximately this way. General revenue, approximately 29%. The Education Enhancement Trust Fund, approximately 2-3%.
I'm sorry, I missed that percentage. What was that percentage from the trust fund?
The Education Enhancement Trust Fund is 2.9%. The Education Trust Fund, which is tuition fees, about 11%. And then other sources like financial aid and contracts, about another 25-30%. And then there's some trail sources.
So of the tuition fees versus general appropriations, what is the percentage?
Tuition fees come out to maybe in 2007 figures, maybe 13, 14, 15%.
Now, their argument, which seems powerful, is that some of the great university systems in the country do exactly what they say this amendment was intended to do. They point to Michigan, California. What's the response to that?
My response to that is if they wanted the Michigan and California model, they should have used the Michigan and California language, none of which appears in this amendment.
Could they have done that without violating single subject?
Well, that's a question I can't answer, perhaps, Your Honor. That's one that's a pretty.
So what additional language?
Only we would know that.
I'm sorry?
Only we would be able to answer that question.
What would be the additional?
It may have been possible to craft it without a single subject problem, but that's not what they did. I mean, it's fairly clear. We set out the constitutional provisions in the briefs. They are very clear in those states as to who controls monies, and it's a university system. That's not what happened here, for sure. I would point out one thing. This is not just like different pots of money. This, as you pointed out, Justice Parenti, is a pie which is composed of a number of pieces. Part of it is tax, general revenue. Part of it is other fees. This court has already decided in a similar context in Department of Education versus Glazer that it is within the legislature's appropriation power to say, we're going to condition the appropriation of tax monies to you in a school and an education system based upon you're agreeing to do the following things to collect money and no more. And the court said that is clearly within a condition the legislature can put on an appropriation for that purpose. Nothing different here. Even if you believe, and we believe that's wrong, but if you believe that the appropriations power of the legislature was somehow restricted just to general revenues, although nothing in the amendment says that, in the appropriation of general revenue, you've already decided that we can then condition the other pieces on what amount of general revenue the legislature gives.
Even if it violates the citizens' initiative with regard to control management. Is that what you're saying?
No, Your Honor, I'm saying it can't violate that.
Cannot violate those, but
because
you can add
it doesn't.
conditions.
Because the amendment specifically said that whatever powers they were given are, quote, subject to the power of the legislature.
Well, I understand, but I'm asking you the question is that if the conditions that are placed upon the appropriation, very clearly, even you would agree that it involves and directly hits upon the day-to-day management and control and operation of the university.
I would not agree with that, Your Honor.
I'm sorry?
I would not agree with that statement, Your Honor, respectfully. All this has to do with is how much
I didn't
is
say
the
this. I'm
pie.
asking you a question, sir, if you could answer it.
I'm sorry?
Is that you're saying that appropriations could put any conditions upon the appropriation. As I understood you say that.
Any condition directly related to the appropriation.
Okay, and well, directly related. That could touch upon how the day-to-day operations of a university would be conducted.
Your Honor, I think
would it not? Isn't that not possible?
I don't believe so, the way you phrase it, Your Honor.
Well, I'm trying to determine if this really means anything at all, this constitutional amendment, because if you're saying that the power of appropriation is so broad that it can just sweep away everything that's in the other constitutional amendment with regard to control day-to-day operations, then I wonder whether you're not interpreting the appropriation power far too broadly.
No, Your Honor, I don't think this case presents a situation where the appropriations power has been used to meddle in the fine management decisions of the university system, such as put this program there. Right. What this is about is
I
who has
understand
the power
that,
to
but
set
you made the
pie.
statement. You made the statement that they could put any condition they wanted on appropriations, and that's what I'm wondering. How far does this go?
It goes only as far as this court allowed it to go in Department of Education versus Glazer, which it has to be directly related to the purpose of the appropriation of general revenue funds.
But,
in closing,
but I guess the purse string. What you're saying then is it can be interpreted broadly to you can apply conditions to any condition you want because you have the power to appropriate.
No, Your Honor, I don't believe that's the case.
Isn't it? You're saying he who controls the gold controls?
Your Honor, even the Chase court, the University of Minnesota versus Chase case that the petitioners rely upon, concludes with this statement: the legislature, while it cannot, even under that system, which is stronger than here, cannot meddle in the day-to-day affairs of the university system, it retains the power to appropriate as it sees fit. That does influence educational policy, there's no question about it. But this amendment did not intend to remove the legislature from a say in state and university educational policy. It just simply can't interfere in the day-to-day management. Their appropriations power was not affected
Well, that would maybe be a different case, because if they decided that they didn't like FSU or they didn't like University of Florida, they liked the new university that they created, and they started to appropriate in a way that was interfered, not just with the day-to-day, but with the policy setting of the universities, that would be
a different case, Your Honor.
That would be, in my view, a violation of this constitutional amendment, and so I hope we're not. If we have to tie a decision here into that kind of thing, then we're going down the wrong path.
You know, that's a different case. That's not what's here. What is being challenged here are simply statutes that say you, the university system, will accept tuition levels at this amount for next year to complement other sources of revenue that are being appropriated to you. That's all this case involves. It does not involve a situation where the legislature has tried to in any way manage the decisions about how the university system will operate within itself. It's creating the amount of funding for the university system. And I think what this court should ask itself in judging this is there anything in this constitutional amendment's summary, its text, the ballot summary, the constitutional jurisprudence of this state that preceded it and led up to it about the appropriations power that would lead a citizen and voter to believe that the legislature lost its ability to decide how much of the funding pie is going to come from taxes as opposed to fees that students and their families must pay next year? Or did they intend it to mean that an unelected board would make that decision?
You're out of time.
Thank you, Your Honor.
Counsel will add an additional 3 minutes to your existing time on rebuttal.
Thank you. I appreciate that. This is serious business. We're talking about millions of dollars. This is the court of last resort. And Mr. Brown says we ought to do it this way because it's the same today as it has always been historically. That's as if the legislature was immune from amendment by the Constitution, the ultimate authority in our government.
Let me ask you this, because it seems to me that you are asking for something that could sort of come back to bite you. If the Board of Governors, University System, authority to set the tuition and fees, then nothing that would legislature from then reducing the amount of taxes, money that coming from taxes, they would appropriate to the university system in direct proportion to how much you could, for example, increase the tuition, is there?
That's about exactly the way that it works. And attached to our complaint, original complaint, is what's called the California Compact, and that strikes the balance. Because what you have is two co-equal, we're talking about the Board of Governors, which is an independent constitutional entity co-equal to the legislature. The legislature has the power through its general revenue to supplement universities, and the Board of Governors over here, because of its power that was transferred by the legislature, it has the power to set the rates for the service that it provides. And then one of the ways you can get stable funding is if the general revenues are down, the tuition can go up. If the tuition goes down and general revenues are better, the tuition can go down. So that's the way universities get stable funding in those states, as distinguished from what we've experienced here.
But this provision doesn't require that. This constitutional provision would not require that kind of stabilization.
No,
correct?
It doesn't require it, but that's the way it works.
So how have you been, I mean, what is the reality? Because have you wanted to raise tuition and the legislature has said no? Has there been one particular thing that's happened that can give us a graphic example of how detrimental the interpretation given by the First District would be to the intent of this amendment?
Well, I don't know that that's the
I mean, 'cause
legal question that
well,
we're
we're talking
confronted
about
with.
real. You know, we're talking somewhat theoretical, and you're saying this is devastating. I just want to know. Could you give me an example of has a university tried to raise fees? The legislature has said no, or is it just the
example I can give you, and it's about something that's in the record, is the survey that was conducted by USA Today, which is an exhibit to the complaint and the original complaint in this case, and they took 150 flagship universities, what they called flagship universities, and as it turns out, Florida's two flagship universities, Florida and Florida State, were it was 50 of them were 49th and 50. They were the absolute bottom.
In what terms? In the bottom, in terms of tuition or?
Tuition. I'm worried about the fact that we're straying from what the legal question is that we have before us. And I would urge the court to adhere to this court's opinion in the Caribbean case, because that's the one that clearly sets out how you go about the method for analyzing a transfer from legislative authority to an independent constitutional board. And all of that legislative authority goes over based on the constitutional amendment unless there is a constitutional exception. And we can just take a look at this. The legislature is trying to find a constitutional exception to this. Well, let's take a look at it. Article 7, no, that's no constitutional exception. That's general revenue. Those are tax funds. And they're the ones that supplement the universities. And let's take a look at Article 3. Article 3, no, all the authority in Article 3 was transferred, so it's not there. It comes down to appropriations. So let's take a look at appropriations. Appropriation is a power that is only on the expense side. It is not on the revenue side.
Except that the article says raise revenue and appropriate. It would be pretty hard for the state to only appropriate if they weren't collecting revenue, would it?
They only appropriate after the revenue is collected, and the appropriations power has nothing to do with the collection of it. And as a matter of fact, if you look at this very amendment, and we were talking about what is retained by the legislature, the power of the legislature to appropriate for the expenditure of funds. Nothing about raising any revenue. Look at the legislature's own definition as to what constitutes appropriations. It's only expenditures.
You've well exceeded your time. If you could sum up.
Pardon?
You've well exceeded your time and your additional time. If you could just sum up, I appreciate it.
Thank you. I think the summary is that all the authority did pass. You have to look for a constitutional exception, and you can look at Article 7, Article 3, Article 4, and there is no exception.
Thank you for your arguments. The court will be in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
Our last case for the day is Southern Alliance for Clean Energy versus Graham. You may proceed.
Thank you, Chief Justice. Thank you, members of the Supreme Court. My name is Gary Davis. I represent the Southern Alliance for Clean Energy. With me today is my partner, James Whitlock, and also Mr. Brian Armstrong, who is representing one of the amicus in this case, and that is the Village of Pinecrest. Also, we have Mr. Leon Jacobs, who is co-counsel in the case. I'd like to start by reading a short summary of the reasons for reversal, which will take exactly 15 minutes.
That worked once. It won't work again.
I thought I would try.
Don't press it.
Your Honor, the statute at issue here, the Nuclear Cost Recovery Statute, is a radical departure from the conventional rate-making procedures that apply to electric utilities.
And we know that, but just from a practical point of view, I want to understand something. For Florida Power and Light, there were two projects, Turkey Point Project and I guess they call it the
operates?
The other one.
EV County.
Of the $196 million, it said that 88% has been unchallenged. Is that correct?
Your Honor, in the sense that we've challenged the constitutionality of the Nuclear Cost Recovery Statute, all those expenditures.
I understand. And there were PSC orders in 2008, 9, and 10 that actually allowed cost recovery for all these projects.
Yes, Your Honor.
So what you're saying is that there can come a time where, even though the costs are being reasonably incurred, because you're not questioning the amount, that because it looks like something has changed and they haven't built it as quickly as they had hoped to, that costs as a matter of law should be denied. I'm just missing that. You can get to the constitutionality, but I'm missing how they could have been appropriate to start. It was determination of need was made for all of these facilities. Costs were authorized in previous years. How all of a sudden it's no longer appropriate costs?
Well, Your Honor, let me just say that SACE participated in the hearings in 2009 and 2010 prior to the order that we're dealing with here, and we did challenge those costs in those hearings. I mean, we challenged... But
we haven't. It didn't come up to us.
Correct, Your Honor. We did not bring it up.
So isn't there something about that if a determination of need is made and costs are expended, reliance on all this, that what changed now that you now come in front of us as to one part of the costs?
Well, the landscape has changed very dramatically about these nuclear power plants.
But that's not their fault.
But Your Honor,
is it their fault?
It's the fault of the projections that they made to begin with, which were extremely rosy from the very beginning. It's also, there has to be some point at which the ratepayers get off of this runaway train and that the Commission puts on the brakes.
Well, this doesn't seem to be a constitutional argument. You seem to be making a factual argument. I mean, our review is not to whether we agree or disagree. The question that we have to look to is whether there's evidence upon which they would base their determinations.
Yes,
isn't
Your
it?
Honor.
And so, I mean, whether we agree or not, I mean, that's a political question with the legislature.
Well, the reason why this runaway train has continued is because there are no standards in the Nuclear Cost Recovery Statute for controlling the unbridled discretion of the Commission.
Well, I mean, it's a prudent standard, and whether a reasonable, we've articulated, have we not, in our case law, what that means, and that if a reasonable business operating person would do it in this fashion, we always leave to the agencies the ability to implement legislation, because it's just impossible to put everything in a statute, don't we?
Well, I wanted to address the prudence issue, and that Your Honor brings that up. And this is, again, this Court has never addressed whether a prudency or a prudent person standard in the utility rate-making context is a constitutional delegation of legislative authority. There's no case law out there that has addressed that issue. And the only case I could find where this court has addressed a prudent person standard was in a different context of ethics legislation, and that's the Dalbert versus Anderson case, 349 South 2nd, 164. We did not have it in our brief, but in that case, this court found that reasonably prudent person language in ethics legislation was unconstitutionally vague. So,
did you file supplemental authority on that?
Your Honor, I did not.
You weren't supposed to talk about it.
I apologize for that, but that is out there in this court's jurisprudence. And I was just trying to find where this court had addressed the prudence question anywhere. And yes, there are cases that were cited by appellees that this court mentioned prudence language in the legislation dealing with utilities, but in none of those was it challenged as an unconstitutional delegation of legislative authority.
But going back to the particular cost that you're challenging, you don't take issue with the fact that before you can construct, you've got to do siting, licensing, and design, correct?
Of course, Your Honor.
Okay, so your argument is it's just taking too long and it's no longer prudent to proceed?
No, the argument is these utilities do not intend to build. They have not demonstrated the intent to build.
And I want to understand, I asked in the prior oral argument, even though we look at statutes, we try to understand this in real life. What would be the business reason that these utilities would continue to expend costs to develop these sites, but they just want to get the ratepayers? I don't understand that as a business thing. Why would somebody continue to throw good money after bad if they really never intend to do anything with this?
Well, Your Honor, we know what a reasonably prudent utility manager would do if faced with the decision of proceeding to build a nuclear power plant with their own money. We know what they would spend. They would spend nothing. It's in the record that if they were spending their own money, they wouldn't be
that's
proceeding.
Why the statute was passed, though. I thought because the legislature wanted to encourage alternate energy sources, whether we think nuclear power is a good source or not. That's what the legislature determined. So they wanted to give, as I understand, utilities an incentive to explore and build these nuclear power plants. But are you saying that they just will continue to spend money even though they don't intend to build it because they know they're going to get it back from the ratepayers?
That's the only conclusion we can draw on the record that we have before us.
So just total irresponsible management.
Well, let's just talk about the facts with regard to that, Your Honor.
These are facts that's going to demonstrate to us that they do not intend to build these power plants.
I will come to that. I was going to respond to Justice Parente's question first. I mean, we've had, for Progress Energy in this case, they came before the Commission in 2008 and said that the 2 new nuclear power plants would cost $14 billion and would be ready to generate electricity in 2021. 3 years later, they came back, and the price was $22 million, and the operation date was going to be 2022. I'm sorry, the first was 2018, and then it became 2022. So we've had a 4-year delay. We've had an $8 billion cost increase in just 3 years.
But the test that an appellate court has to apply is not whether there's any evidence that supports your position. The question is there any evidence to support what the Public Service Commission did? Isn't that our standard?
It is, Your Honor.
And isn't there testimony, direct testimony from high-ranking officials that, yes, they are proceeding, they do intend, and is that not competent evidence?
Well, let's look at the evidence.
Well, I mean, is that the evidence?
Let's look at I don't believe it is, Your Honor.
You don't believe there's any statements from high management or officers that make the statement that we intend to proceed?
Well, let me read a statement that we have.
Please, you can read that. Could you just answer the question? Is there not? Because maybe I'm misled.
Let's take Florida Power and Light first, Your Honor. Florida Power and Light's CEO came before the Commission and said that we are going to get our license. Our intent is to get a license, and then at the time we get our license, we'll decide whether these power plants are needed. So all of these utilities are doing, and the record is replete with this. There might be a statement of a Progress executive in response to a cross-examination question that we intend to build, but the record as a whole, the whole record in this case, totally refutes that.
But isn't But isn't the reality here that these types of projects are very long-term projects? They are very complex, and the world is a dynamic place, and things change. And the recognition that some circumstance may occur which would cause the plans to change is just a recognition of reality. And hasn't the legislature recognized that in the very statute that we're called on to consider here?
Well, the only two standards in the nuclear cost recovery statute are, one, that it has to be an alternative cost recovery mechanism that will promote nuclear power. That's one general policy. And the other is that the costs have to be prudently incurred. That is all that is in the statute we're dealing with here, Your Honor.
Isn't there a provision, and I don't have it here in front of me, but isn't there a provision in the statute that basically acknowledges that some projects may be started and not completed?
There's a provision that allows the utilities to cancel a project and then still recover all the costs.
All right. That's my point.
That is correct.
That's what I was talking about. I don't know what about that wasn't clear from the first time I brought it up, but that's what I meant.
Well, and so the customers can be charged even if there's never any electricity that is generated.
Well, that's not, but again, you're raising a political decision, determination made by representatives of the people we have to deal with. We may agree with you on that principle, but we can't reverse a case on that principle out of this court.
That's true, Your Honor, and that's not what we're asking the court to do. And let me go back to Justice Quint's question about the intent to build and what evidence is in the record. The Commission relied upon very preliminary, very just squishy kinds of activities that in order to say that these utilities intended to build these plants.
You're talking about the original decision when the petition was entered.
I'm talking about the 2011 decision that we've challenged here.
Oh, okay.
And as we've set out in our brief, is in 2010 in the docket, the Commission set a policy that said that the utilities had to demonstrate an intent to build to continue to get cost recovery under this statute. And so in 2011, we focused on the issue of intent to build. And all the Commission came up with in terms of what supported that were very limited activities that don't demonstrate the intent to build. For instance, for progress, one of the activities the Commission listed was the continued disposition of long lead equipment purchase orders, meaning canceling equipment. That is the opposite of the intent to build. So what the Commission relied upon refutes the intent to build in that case.
Does the Commission have the authority, if they see at some point that it looks like, again, you're throwing good money after bad, is it up to them to then say you do not continue any more expenditures, we're not going to reimburse you? In other words, it doesn't seem that the court really is in the position to adjudicate this, nor is our case law ever said that we get into the actual evidence in the case. But is there anything that stops the Public Service Commission from exercising its responsibility to say, just like we told you there was a need, you met it, now we're looking at this and any future costs will not be recovered?
The problem is there's nothing in the statute to say that. There's nothing in the statute that gives the Public Service Commission the power to say enough is enough. And that's why
if at any point they decide the expenditures aren't prudent, can't they disapprove them?
But, Your Honor, in this particular situation where you have advanced...
is that right or not? I mean, tell me if I'm wrong.
If they said they're not prudent, yes. They couldn't get...
So isn't that really... I mean, again, you're saying that's not sufficient, but the Public Service Commission is, we've said over and over, is the agency, the entity that is charged with the expertise of regulating the utility companies, and that this court really can't step into the shoes of becoming a super regulator.
But in a case like this, Your Honor, where prudence is all there is in the statute to govern this exercise of authority, it's not enough, because we're looking ahead. Prudence normally looks backwards. Prudence normally looks backwards to what a reasonable utility manager would have spent given facts that we know today, given the circumstances that can be seen and measured.
Well, is the statute unconstitutional on its face or as applied? What is your argument?
It's unconstitutional in both ways, Your Honor. But
so it's just from the outset there was no way that the Public Service Commission could discern enough guidelines in order to make a determination of when a cost recovery was proper.
Well, and the term is prudent, and in this case, you know, as I said, prudence is wholly speculative because you're trying to look ahead 20 years and predict what's going to happen in the market at that point, and so prudence isn't enough. You know, like I said, we know what a reasonable...
But that's an argument for never allowing a project like this at all. Isn't that correct? And
no,
then
Your Honor.
Essentially, your position that you're against any nuclear power project. Isn't that your client's position?
No, Your Honor. That's not true. Our position in this case, and as it has been throughout, is that there have to be some curbs on the authority of the Public Service Commission to continue to spend the ratepayers' money with cost overruns and delays year after year. And prudence is not that. Prudence is not a provision that can work in a case like this where the Commission is being asked to gaze into a crystal ball every year and guess whether a reasonable utility manager would spend money on nuclear power today based upon this unpredictable future.
You're in your rebuttal time.
Okay, thank you. I'll go ahead and sit for the moment, Your Honor, and let Mr. Armstrong speak.
Good morning, Justices. My name is Brian Armstrong, and I'm the attorney for the amicus, which is the Village of Pinecrest. The Village of Pinecrest is a customer of Florida Power and Light. We are looking at this in a totally different perspective than what the discussion has occurred so far. To us, the standard to be applied is the standard which is applied in every other rate-setting statute in the Florida statutes, which is a fair, just, and reasonable standard, which applies to rates. And you're going to find fair, just, and reasonable standards or some similar standard in every rate-setting statute in the Florida statute.
So the way this works is that when they come up with these monies that's being expended to do this nuclear power plant, you get a rate increase to cover it. And so is that how this works?
Justice, there are actually, in 28 years of doing rate cases, there are 3 steps in a rate increase application. There are 3 steps in determinations by the Public Service Commission. The first is the decision and the action by the utility prudent? That's really an issue in the case. Is the action prudent? And there's a standard applied. Is that what a reasonable manager would do? The second step is always, okay, if we have a prudent act, these costs associated with that act, are they reasonable? And what's applied is a standard that says, well, have they done everything and applied all due diligence to reduce the costs? Therefore, they be reasonable. The third standard, and that's the standard that's missing here in this statute and gives the Commission unbridled discretion, is whether or not the rates that are going to be affecting customers are fair, just, and reasonable. That's the standard that we're appealing. That's the standard that we say the law gives them unbridled discretion. Now, how is that demonstrated? If you look in the Commission's order, the February 2011 order, arguments were made to say that these costs should be shared. The risks should be shared among shareholders and others until the plant is built. The Public Service Commission said, no, we don't apply a fair, just, and reasonable standard to here. The legislature said it's not in the statute. Every other statute in the state of Florida all the Florida Chapter 366 has fair, just, and reasonable or something like that. But the PSC said, no, that's not in the statute. We can't disallow any of these costs. But then in the same breath and nearly in the same sentence, they said the utilities had asked to recover these costs over a certain period of time. And the PSC said, well, that's fair, just, and reasonable to allow them to recover those costs over a certain period of time. Your Honors, I think it's a reflection of the very issue we have here. The legislature didn't give them the standard to apply when they said what should the rates be. They ignored what should the rates be, and they just went to look at the prudence and the reasonableness determinations. Those are the first 2 steps, Your Honors. The third step is the critical step. Are the rates being charged fair, just, and reasonable? And that was left totally out of the statute.
Is there anything in this record about whether the rates are fair, just, and reasonable, or they said they were not even going to entertain
They didn't even entertain it. They said because the argument was made there should be a risk sharing, but the Commission wouldn't entertain it. They said the legislature didn't give us that standard. We are not going to apply fair, just, and reasonable.
So what would happen if in fact, Florida Power and Light decided they were not going to build this plant after, years of rate increase?
It's a wonderful question because it really comes down to the fairness and the application of this fair, just, and reasonable standard. If it is to be applied, Justices, what happens is the Commission will look at not only the costs that are being incurred here, but whether or not it's fair to load those costs on top of existing rates, because they'll have to look at whether or not the utility is actually earning its authorized return, or whether there are other cost decreases that are going on at that point in time that would say you don't raise the rates at this point because they're achieving.
Well, I guess
their
my
return.
real question is, do you get a rate decrease?
Well, I would
if you decide that if either of the entities decide they're not going to build these power plants.
Just as I've been on the other side of the fence, I've represented utilities in the past. I know what retroactive rate making is. I know the order that's being challenged here, and we're the first time into this, but the order being challenged is just a recent order. I would suggest that if the court determines the statute is unconstitutional, that at least the rates that have been implemented under this order should be refunded to customers.
But there would be a different, the fair, just, and reasonable, it seems like it's a different than the separation of powers argument being made. Are you saying that the legislature, by not including fair, just, and reasonable, that they didn't give sufficient it seems like different than some of the other cases?
Your argument, exactly my argument. And if you look at, I don't know of any rate case appeal that this court has decided, or any court of appeals, where they don't look at some form of fair, just, and reasonable rates when they look at that third step, the rates. And that's my argument, Justice, that the legislature didn't apply that standard, didn't say whether it should be fair, just, and compensatory, fair, just, and reasonable, fair, and reasonable. And if you look at all the Florida statutes, you have that standard somewhere. That is the standard that should be applied. They left unbridled discretion to the Commission, which is why the Commission in this order that we are challenging said we can't look and determine rates of whether they're fair, just, and reasonable, because the legislature said include all these costs. But then when it came down to the recovery of those costs, over whether it should be over 5 years or 10 years, then they said, oh, it's fair, just, and reasonable to allow that to happen. They left them unbridled discretion. They don't know what to apply.
Thank you for your arguments.
Thank you very much. Thank you, Your Honor.
May it please the Court, Samantha Sabula representing the Florida Public Service Commission. My first point I want to address is the option to bill versus the intent to bill argument. FP&L in progress testimony that they are pursuing an option to build does not contradict the utility's testimony that they intend to build the nuclear reactors. Both FP&L and progress testify that they intend to build the nuclear reactors, and the record shows that they are moving forward with the projects to meet the projected in-service dates for the plants. As both
let me ask you this. As I understood your opponent's argument is that there's evidence in the record of returning equipment or something to that effect that indicates just the opposite of what you just said. Is that true?
There's evidence in the record that FP&L witness Diaz testified that the stepwise approach to contracting and constructing utility was consistent with minimizing nuclear power plant costs and with best management practices. And also there was an order that we issued in 11-0095 in regard to Progress Energy Florida, where they came to the Commission and asked whether they could defer going forward with some of their construction and instead concentrating on getting their combined operating licenses. And we said that was reasonable. And that decision was not appealed, and it's final. And the record shows that Progress is following that plan that they submitted to the Commission. And like I said, there's evidence for FP&L showing that the stepwise approach to concentrating on getting their licensing and deferring some of the construction aspects of it was a reasonable approach to take at this time.
This last argument that Pinecrest is with regard to what's in the statute, what's not, and standard that the Public Service Commission applied, do you read the briefs and arguments as being a proper argument, or is that one that's just raised by amicus? And number two, if it's properly before us, what's your response?
I think that is an argument outside of what SACE has raised. What they're arguing is actually a decision that the Commission made in a prior order in regard to joint ownership, and the Commission had determined at that point that we did not have to require the company to enter negotiations to jointly own these plants. And our basis for that decision was that the statute specifically says, the statute at issue here specifically says that utility companies are allowed to recover all their prudently incurred costs for the siting, design, licensing, and construction of a power plant. And if we force the utility companies to jointly enter joint ownership with the power plant, then they would be maybe waiving their right to get cost recovery under the statute. And the statute was very specific that it says that you can get all prudently incurred costs.
That's the response to his argument?
That's the response to his argument.
Fair, just, and reasonable standard?
And in regard to that, the legislature in this statute has said that they can get prudently incurred costs. Therefore, it follows that those would be just, fair, and reasonable rates that would come out of that.
Even though it's not stated in the statute?
Even though it's not stated in the statute.
But isn't the problem there that it's one thing whether it's prudent and reasonable, but whether then the ratepayers isn't there any difference in whether it's reasonable to expend and whether it gets passed on to the public?
Well, that's all in the prudence determination.
So you think it's subsumed?
Yeah, it's subsumed in that.
So all the statutes that talk about fair, just, and reasonable, that's just surplusage?
No, that's not surplusage. That is an aspect. We look at, in even our fair, just, and reasonable statute, we still look at when we are determining whether to allow a cost recovery, we look to see whether that cost that they incurred was prudent.
Well, obviously that's the first step. It's got to be prudent and reasonable, but you're saying there's no other standard for whether the ratepayers have to pay the increased amount for electricity in this situation for plans that may never go online other than it was prudent and reasonable?
Well, the legislature made that policy determination that they want to encourage nuclear investment in nuclear plants, and that was a determination that they made. And they said you can recover all. Does there come
a point, however, when all of these costs, whether you find them to be prudent or not, if it would increase the rate that someone is paying so dramatically, that doesn't come into your determination at all?
That might go into the feasibility aspect of it. We require the utilities.
Well, I thought you would have made the feasibility determination at the time when they petitioned for.
It's actually a continuing review. Every year we examine whether the plants are economically feasible, technically feasible, and the utility companies are required each year to put on evidence showing that they are.
Well, isn't one of the arguments, though, that you do decide whether it's going to be recovered in 5 years, 10? I mean, doesn't that impact what the rate is? So that if it's recovered over a longer period of time, then the ratepayers don't pay as much.
I think there's a provision in the statute that says if it doesn't come into service, then it says that they can recover it over 5 years' time. What we're doing here is each year we examine what costs the utility incurred, and we examine to determine whether it's prudent or not. We project some of the costs. They come in and say, we're going to incur these costs this year. Commission, are they reasonable? And we look at that and determine whether they're reasonable. And then when they actually incur the cost, they come in and say, ask us to review whether it's prudent. And we make a determination of whether it's prudent. And in that prudent determination, we examine every year whether or not the the plants are still technically and economically feasible. The utility puts on testimony about that, and we also do an independent audit ourselves to determine that.
And then when does the rate part come into effect?
Then the rate part comes into effect when we include the reasonable rates in that are projected forward and the rates we determine are prudent, and then the next year we look at those rates that were projected to determine whether, once we get the receipts, to say whether this was a prudent cost. And then if the cost goes up or if the cost goes down,
what actuality, if, following up on Justice Quince's question, what if the utility said we're going to charge all residential customers an extra $1,000 a month? How does that get factored into the analysis?
Well, they can't do that. What it is they have to show we spent money on this part of the plant, and this is how much it costs. And
well, what if they show this is going to cost this amount of money, and we're going to pass that amount on to each resident?
Yes, we look at that, and if they have to show that it was prudent, and we determine whether or not it was a prudent cost. And in that equation is whether or not, at that point in time, the plant is technically, economically feasible.
But how does it get factored in, though, as to the resident? I mean, I understand the analysis as to whether it's feasible as to the utility, but what about the resident?
The actual dollar amount, yes, it goes into the rates. There's a line item in the capacity.
But what analysis is there by the PSC to say this is a reasonable rate to be passed on to the consumer?
We hold a hearing every year where we look at what the cost was and whether it was prudent or not. And in that hearing, we take testimony, and we determine based on that testimony whether that cost was prudent.
So is that separate from this? Is that separate from this order?
No, we did that in this order. Every year we do that. We hold a hearing.
It's all part of the same proceeding?
Yes, same proceeding. It's a revolving docket. Every year we examine these
every
costs.
Year the customers of these utilities, their bill goes up based on money that was expended for power that may never get used.
Yes, if they've shown that cost was prudent, then we say that yes, you get cost recovery for that.
That's what the legislature said.
And that's what the legislature
I understand.
says. And that's the legislature said they want to promote nuclear investment in Florida, and they told us that's what.
So what kind of percentages have we seen over the years since these petitions were approved?
I don't know the percentages. The amount that's in the order are more than just for the plants that are at issue here that SACE has raised. There's also some up rates that are at issue as well. So the dollar figures that are in the orders that you see includes other plants besides what.
These particular plants were approved in 2009?
I think it was
2008?
I think it was 2008.
But has there been a rate increase every year since this approval of this petition?
Yes.
Could you, maybe I missed your answer, but it seems to me that Chief Justice Polston asked a question that still has not been answered. Okay. We've got the equation on one side, what is prudent? And a good power company like Florida Power and Light, may decide that we really want the walls to be X thick and what have you. It's going to be the Rolls-Royce of nuclear power plants. What about the equation on the ratepayer side? That's what he was asking. Where does it come into? That may be well and good, that may be prudent, but where is the decision, or where is it factored in when it goes overboard from the ratepayer's view? That's what he's asking.
So are you asking at what point do the costs become too high?
Right. Where is that factored in? As I understood the question, it could
again,
come
I think that goes into
$50,000 bill to a rate.
I think that goes into the feasibility study. Is it feasible economically to continue to invest in this plant? Is it getting too expensive? And we look at that every year. We do feasibility studies to look to see whether or not it's going to be so high that it's cost prohibitive to build the plant.
I guess the question is, how do you determine whether it's feasible for your customer in terms of their individual bills? When is it too high for a customer? I think that's what they're trying to say.
Yeah, is it the determination that in the feasibility analysis that you look from the utilities perspective and say you're just not going to be able to collect this amount of money from?
Well, we do an independent. We look at it ourselves at the Public Service Commission and do an audit and say, is this still technically and economically feasible? And in our expertise, we look at that. And then they put on evidence as well, and we weigh all that. And there's a hearing. Do you do that
every time there's a rate increase? Or
every time we have a hearing every time there's a rate increase.
And what percentages have there been increases each year?
I'm not sure about that.
Your time has expired.
May it please the Court, Raul Cantero for Florida Power and Light. The only thing I would add on the feasibility issue in answer to Justice Lewis's first question is that is totally outside the issues on appeal. The issues on appeal that SACE raised and that the amici are bound by are, number one, was there substantial competent evidence of an intent to build? And number two, is the statute constitutional on its face? Respectfully, those are the issues that we should be talking about.
And they didn't raise the failure to have the standard of fair, reasonable.
Not at all.
And it's unconstitutional. That's not part of today's discussion.
That is not.
Thank you.
As to the intent to build, our position is that that's nowhere in the statute. It's nowhere in the regulations. What the statute requires is, number one, that there be a determination of need for the project. And that itself, which is in section 403.519, contains very detailed provisions about what would constitute a determination of need, and includes the policy to encourage diversification of our energy sources in Florida and reduced reliance on fuel costs, on fuel oil, and natural gas.
But all of that, did I understand you correctly when you said all of that does not include an intent to build?
Correct. Well,
so
here's where the intent to build comes in. That's where I was getting at. The intent to build, which is included as a phrase in a previous order of the commission, and which the commission cited here, is a short form way of saying you've determined the need, you've expended these costs on siting, design, construction, licensing, and those costs that you've expended are prudent. If you prove all those things, you've proven an intent to build the project. Why are you going to expend all this money on licensing? And we've spent $27 million just on licensing.
But the people have actually spent that.
I'm sorry?
The people have actually
spent.
Yes,
because the legislature decided that, remember, the reason why that statute was enacted is they haven't built a nuclear power plant in 30, 40 years in Florida, and the legislature decided we want to encourage utilities to build nuclear plants because in the long run it's going to reduce costs.
What happens, this is very important to me, what happens, you've gone through that petition process and all of that. You have spent several years expending money that has been passed on to the customers. And then at year 6, something happens and there is no building, there is a determination not to build this power plant. What happens at that point? The rates continue to stay at the rate they are at that point. Is that basically what ends up happening?
Well, the rates may decrease because the costs in the future aren't going to be expended for that power plant. So in the future, those rates may decrease. But the rates may increase due to increased costs for natural gas or fuel costs. So there are other variables. But the statute specifically...
I guess the real question is there now some kind of adjustment to the rates because no power plant is being built? And you're representing Florida Power and Light.
Yes.
And so at any point, is it then factored in that since the people don't have this power plant that they've expended money for these 6 years, does Florida Power and Light then have any obligation to absorb some of that money?
Of the past costs that were expended?
Yeah. Mm-hmm.
No.
Okay.
And that's specifically in the statute. Mm-hmm. And that is not a basis that SACE has alleged for the unconstitutionality of the statute. They don't raise that.
That's a legislative determination.
Yes.
If it's not fair to the ratepayers, the argument is to ask for the statute to be repealed or amended. It's not a basis for saying the statute's unconstitutional.
Right, and they haven't raised that.
Specifically, it wasn't raised. That's
correct.
So the only constitutional argument was whether this is too broad of a delegation of power to the Public Service Commission.
Correct, Your Honor. And if I may address that issue, given this Court's prior precedents, and especially the Microtel case and the Florida gas case, the delegation here was within the Constitution. In Microtel, the delegation was that was where after AT&T had been dissolved and the legislature wanted to encourage competition in long-distance telephone service, and it left it to the Public Service Commission to determine whether it was in the public interest to determine a certificate, to grant a certificate for long-distance service. And this Court said that even in that case, where it was up to the PSC to determine public interest, that was sufficient, a constitutional delegation, because it's a specialized area and it's within the Public Service Commission's expertise in a complicated area to determine those issues. The court said the same thing in Florida Gas, despite language in the statute saying that you can, that the PSC can determine a certificate of need based on certain parameters, and then said the phrase, and other matters within its jurisdiction that the PSC determines relevant. That's the same we have here. Costs are recoverable, and it says including but not limited to certain costs. That's what they claim is an unconstitutional delegation, but that's perfectly consistent with this court's prior precedents. On the intent to build, I said that it's really a short form for have you complied with the statutory requirements. But even if you determine that there is some kind of requirement of intent to build, as Justice Lewis questioned, we have evidence in the record that we intend to build. And SACE's argument is that we kept talking about an option to build. And there is specific testimony in the record responding to that argument. And it's in the record. The transcript is at volume 53 of the record. This is a 12,000-page record. And at volume 53, the second volume of the trial transcript, the FPL witness states the following. So I think the option has been perhaps twisted to make it sound as if we would or wouldn't choose to. We intend to. We wouldn't be engaged in the licensing process if we didn't intend to. And it's really a question about when is the appropriate time to initiate the construction expenditures. And what the Public Service Commission said about that in the order is that it was a deliberate, stepwise approach that strikes a balance between maintaining progress of the project and managing the risk by managing commitments. And then it said that FPL's risk mitigating actions should be commended, not used in an attempt to cast doubt on its commitment to the project.
I just want to make sure I understand something. The need to build was approved by the PSC when? Was there a need determination? The determination of need was back, I believe, in 2008. And that was never appealed?
That was not appealed.
And there was orders in 08, 09, and 10 never appealed to this court that allowed cost recovery for these same exact projects?
Yes.
And in this time, of most of the money, most of it isn't even being challenged.
88% of it is not being challenged.
So because I know they said, well, we challenged it, but it just seems to me that it puts the court in a very difficult position, and perhaps FP&L. If there was a real issue, it should have been brought to us, it seems, at the outset.
Yeah.
But does there come a point where what you're doing becomes no longer prudent? I mean,
there may come a point, Your Honor. We haven't reached that yet. The PSC every year determines the prudence of the project. But let me, as an example, why they did not appeal the EPU project, which was 88% of the expenditures.
EPU. You know, I knew there was,
EPU.
okay, EPU.
Right. And probably the reason they didn't challenge it is because that's already partially online and already saving customers money. So we've demonstrated that this process under the statute works. It's already saving the customers money. We've demonstrated that once the Turkey Point project goes online, over the life of the project, it's going to save $75 billion to the customers. So the customers will get a benefit. Now, it costs a lot of money to build it, and that's why the statute was enacted, because the utilities don't have the money, can't borrow billions of dollars, so they needed incentives. That's why you don't see nuclear plants being built, and states are starting to give incentives to build it. That incentive is working, and that's demonstrated by the EPU project. Thank you very much.
Please the court. My name is Stephen Grimes, representing Progress Energy. In response to your question, Justice Quince, if at the end of 6 years a utility determined that it was just not feasible to go forward,
or just don't want to
and
go
all
forward.
things being equal otherwise, the rates would go down because there would be no longer any more costs to be reimbursed for, and therefore the rates would necessarily go down. There are only two issues.
Well, but just on that, it seems that, I guess that, and maybe that's what the legislature intended, that the utilities are in a win-win situation. They can make a decision for any reason in 6 years not to continue, and they haven't lost anything, but meanwhile the rate holders in the state have lost, what amounts to hundreds or thousands of dollars. So, I mean, you agree
that's what the statute says.
Okay.
There was reasons for it. If you go back and look at the ALR article that we cite in our brief that points out back in the 80s, a lot of utilities were building these plants, and for one reason or another, they had to stop and couldn't.
Like maybe 3 Mile Island?
No, maybe that was one of the reasons. But and then there was a lot of litigation as to whether they had built them on their own, and there was a lot of litigation as to whether they get their costs back. And in most of the cases, the courts allowed them to get their costs back, even though they didn't finish. Sometimes they didn't get their costs back. The legislature was obviously aware of this. Nothing had been built since that situation for 30 years, and so they put it in there that would be actually so, that they're prudently incurred costs that they would have properly been reimbursed.
What's the difference between reasonable and prudent?
Yeah.
What is the difference?
I don't see any difference really, but basically what the statute says is prudent. And prudency has been in the U.S. Supreme Court, in the federal PERC, and is recognized in your decisions and referred in all as a way to determine something is reasonable. I guess they're essentially the same as I see it. But there were just two issues here, and Sage has kind of tried to expand the argument. But was there an intent to build? In the case of Progress Energy, there was the commission found ample evidence there was. Our witness, Mr. Elnitsky, said there was an intent to build, and he outlined in detail, and we point that out in our brief, the various things. What they've been doing recently has been trying to get that license. And so they didn't cancel their contracts. That term disposition has been misunderstood. They had contracts for construction of some of the equipment, and they have deferred those. The deadline for doing it, they've extended that deadline because it wouldn't be reasonable to be doing a lot of construction and charging for it, and then thereby increasing rates again if, for example, you never got the license. So right now they're spending their time seeking to get the license, and that's what the costs that they're being...
Well, I'm confused. On yours, you've got Crystal River, Unit 3, the improvements, and you've got Levi Levy Nuclear Project. Mm-hmm. Did yours start also in 2008?
I think so, yeah.
So they went through 2008, 9, 10, 11, and now they're just still trying to get a license? I would think the license...
Getting a license...
I guess I sort of thought the license was the first
license
part.
from the nuclear energy takes years and years. They have all kind of engineering, environmental permitting.
So is that the way usually a license, it doesn't precede the building?
The license precedes the building. Sure, you can't start building.
So what's been all the costs over all these years? If it's for 4 years, is all licensing?
It's primarily on licensing, yes.
That means
citing and licensing, yeah.
Is it engineers, attorneys?
Yeah, all kind of. It's incredible. It's incredible how difficult it is to get a COL.
Well, it's incredible how expensive it is. Somebody's making a lot of money off of this.
Well, nobody's making any money. This reimbursing.
No, I'm saying
expensive.
The people that are charging for trying to get the license, whoever they are. How much money has been spent trying to get a license for these facilities?
I can't tell you that.
It's
been substantial.
Sounds like a good sideline for somebody, huh?
Sure. It's been. It's not a win-win in the sense that they're not making money on it.
No, I'm not saying the utility is. It's just that we don't usually think of getting a license as being multi-millions or billions of dollars. That's all. But it must be. And I'm accepting it. I just.
In any event, they've just moved their contracts back so they don't have to spend any more money at this point. We have showed the intent to build, but our intent, our option is not to build if the circumstances arise that dictate that it would be not feasible to do so. And there's a specific finding that we have an intent to build, and they have not challenged any cost whatsoever. They didn't even put any evidence on. The states didn't introduce any evidence on anything about cost. On the constitutional issue, the delegation of authority, in order to encourage nuclear power, the legislature recognized that they had to provide some way for the utilities to collect as they went along, and that's why they specified an alternative cost recovery mechanism, and they laid it out in the statute, and you will have these two particular alternative cost recovery mechanisms, and that's exactly what the Public Service Commission authorized. The first is and they define what costs are recoverable, and what are pre-construction costs, and what are construction costs. And the first mechanism is for the pre-construction costs. The second one is for the construction costs. And that's exactly what the PSC did.
Let me ask you about, in a normal situation where it's not a nuclear power plant that we're talking about, if it's just a regular plant that would provide for electricity, all the costs would be, the company would have to do the cost up front themselves, and then on the back end, the rates may go up. Is that how it normally works?
Yes.
Okay.
But that's correct. But this was different because they knew that no company would be ever willing to do that.
But even on the regular situation, I'm not finished with that part. On the regular situation, at the end, are all of the costs that were associated passed on to the customer, or is there some determination being made of which of the costs to produce that kind of facility would be passed on?
I would assume that the PSC at that point would look again and see if those costs were prudently incurred. I don't think that.
So you're saying that even in a regular situation, that if they're prudently incurred, every bit of the cost could be passed on to the customer.
That's my understanding. Plus a reasonable rate of return, actually. On the constitutional issue, it's clear that they provided the alternative cost recovery mechanism. It's in the statute. It's in the PSC rule. The prudency requirement is a well-recognized requirement everywhere in the federal courts, your court. And if any particular, if it came to a point where it did not appear that the utility had any more intent to build, or if it wasn't feasible, then the PSC would have the authority not to approve the cost because there wouldn't have been any more costs, because they would not have been prudently incurred. And at that point, then the utility would be on its own. If it wanted to finish on its own money, perhaps they would, but basically the plant would be shut down under those circumstances. But the two issues that I would emphasize, that the only two issues here are intent to build and the delegation. And the wisdom of this statute, it's almost like they're trying to make it a referendum on whether it's a good idea or not. That's not before this court. And we respectfully request that the PSC be affirmed.
Thank you.
The order.
Your Honors, I want to address a few points in my remaining time. The first, I just want to say that SACE did address in its argument the fair, just, and reasonable question. we said that prudence is not a sufficient standard to ensure that rates are fair, just, and reasonable in our brief. So I think that is in play from the amicus in this case. Now, the reason that we believe that the statute as it's written is unconstitutional is because of what a lot of this discussion brought forward, is that it doesn't provide any adult supervision over what rates are ultimately going to be charged to the consumers of the state of Florida in this case.
Well, the response to that was in the feasibility study.
But I just want to make clear, that's a very good point, Your Honor, because the feasibility study was done by rule. That is not part of the legislation. The legislation doesn't say anything about a feasibility study. The Commission has been trying to fill in...
But isn't that what the deference to the expertise of the Public Service Commission is about? A statute can't necessarily put down each and every rule that they enact, can they?
Yes, Your Honor, there is deference when there's guidance in the legislation that's specific enough. I mean, this court has said that, yes, you can defer if it's a very complex situation, but there has to be...
Prudence in the statute?
Prudence is in the statute, but prudence is not enough of a standard, and particularly in this case.
What page in your brief did you make reference to fair, just, and reasonable rates? You said you mentioned it in your brief, right?
It was in SACE's reply brief, Your Honor.
Oh, but to present an issue here, don't you need to talk about it in your initial brief?
Well, in general, we talked about the fact that the prudence standard...
I just tried to find it in your initial brief, and I searched the words, and it wasn't. I couldn't find the word fair there.
I don't believe it's in our initial brief, but we did say that there's not enough of a standard to ensure that the rates set are in the public interest, and we did say that the standards are insufficient, and this is just one more example brought up by the amicus of why the standards in the statute are insufficient. Now, when it comes to the prudence question not being sufficient in this case, I think that is the key point. We're not arguing that prudence can never be part of objective standards, but when we have an advanced cost recovery like this, and the utilities are coming in front of the Commission every year and saying that just ignore that $8 billion increase, ignore that 5-year delay. We can predict the future better than you can, Commission. We know that the future is rosy for these plants, and therefore keep charging the consumers for our costs. That is where prudence falls apart in this case. As Justice Quince pointed out, the normal case is where you have a plant that's been built. You can look backwards at a reasonable utility manager standard in that case and say, you spent X dollars on the smokestacks or whatever, and that was a prudent cost. But when you're in a situation where you're trying to project 15 years from now whether a nuclear power plant is going to be justifiable, and it keeps slipping further and further out.
Isn't it the state is the one that asked for the power plants, right?
I'm sorry, Your Honor?
Did the state ask kind of to induce people to build nuclear power plants in the state?
That is one of the general principles in the cost recovery statute.
Before the state passed this statute, was anybody planning to build a nuclear power plant in the state?
No, Your Honor. But this is like the Askew versus Cross Keys case. In the Askew case, there was a general policy in the statute. The statute said, go forth and protect areas of critical state concern. And what the Supreme Court held about that is that wasn't a sufficient standard to guide the agency in implementing the statute. And that's what we have here. I see my time is up, Your Honor. We would ask you to strike this statute. Thank you.
Thank you for your arguments. The court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.